My name is Will and I'm part of the team here at Edwards Law. In this video I will briefly outline restraint of trade provisions. A restraint of trade is a provision that may be included in an employment agreement or in an independent contractors agreement. In the context of employment law, it can restrain what an employee can do after their employment ends. A restraint must be reasonable and necessary to protect some legitimate proprietary interest, such as confidential business information, and must not be excessive in terms of its scope, geographical area or duration. On occasion, wider public interest considerations are also relevant. When assessing the reasonableness of the restraint, the Employment Relations Authority and Employment Court will balance an employer's need to protect its proprietary interests against an employee's right to continued employment in their given field of expertise. If an employer is relying on a restraint of trade provision, it must show that the employee received due consideration for agreeing to the restraint. Usually, an employee's remuneration will be sufficient consideration. However, if the employer is seeking to amend the employee's terms of employment to include a restraint, the employee should be offered additional remuneration for the restraint. Otherwise, the restraint may not be enforceable. If an employer is seeking to enforce a restraint, the first step can be to write to the employee, putting them on notice of their obligations. The employer may also seek to enforce the restraints against the employee through the Employment Relations Authority. If this is not successful, the employer can initiate proceedings in the authority against the employee for breaching their restraint of trade. If a restraint is found to be unreasonable, the authority can either decline to enforce the restraint or modify the restraint until it is enforceable. This can include modifying the duration or geographical scope of the restraint. We've seen many issues with restraints arising because of redundancies. Employees are often looking for certainty as they go back into the labour market and are in need of negotiating a reduced scope of the restraint, whereas employers are seeking to protect their confidential information from competitors. If you're an employer who would like to ensure your interests are protected, or an employee looking to clarify your restraints, do not hesitate to contact us here at Edwards Law.